Good morning, Mr. Roy.
Good morning.
Morning. We'll get started. I'm just going to wait for your attorney to get here and then we'll get started, okay?
Okay, thank you.
Good morning, Mr. Roy.
Good morning.
Morning, we'll get started. I'm just gonna wait for your attorney to get here and then we'll get started, okay?
Okay, thank you.
All right, Mr. Roy, we're gonna get started with your revocation hearing, okay?
Okay,
Morning, Mr. Roy.
good morning.
Good morning, I'm P.O. Meissner, a hearing examiner for the Board of Pardons and Paroles. Revocation hearing concerning Roy Raymond, number 218053. Today is November 12th, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Raymond Roy, 218053.
You have counsel here today.
Sure. Attorney Alfonso Sirico with the Parole Revocation Unit on behalf of Mr. Roy.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence for the violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review pro violation charge, state your appeals are against you. I will review and identify exhibits filed for the record. Council will then have an opportunity to present relevant testimony. After considering all the evidence presented on my findings, if I find that you have violated one or more conditions of your parole, council will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, your important rights, your right to have an attorney present and you have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
You have a right to review the evidence. You have a right to submit evidence in support of your case. At this hearing, the right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes, ma'am.
Okay, so we'll now review the charge that the state of parole is bringing against you and your commission underlying each charge. Charge one, to obey all laws, obedience to the law. Your charging officer reported at 9/7/25. You sold a pair of boots by putting them on your feet without paying for them and subsequently crossing the last point of sale inside Walmart. You were subsequently arrested by warrant for the charge of larceny 6. And the state has filed the following exhibits pre-marked for identification purposes as Exhibit A, remain in custody, B, CT parole condition, C, notice of parole violation, D, parole violation report, E, notice of police arrest warrant. Did you receive notice of parole violation report, and the other documents I just marked? Did you review them?
Yes, ma'am.
And council has filed the following exhibit pre-marked for identification purposes as Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Exhibit 2, which is support letter from significant other, and Exhibit 3, which is letter from current employer. Do you need to continue the hearing to obtain any additional evidence? We have no witnesses. I did receive the addendum from PCS. The addendum reported 9/23/25. You are convicted of larceny 6. Received a 30-day jail sentence, which was fulfilled on 10/22/25. So now it is defense's opportunity. If you'd like to speak to any of the evidence submitted at this
Yeah,
time.
just briefly on the first part of the hearing, because it's a singular charge of obedience to the law. I did speak to my client. Obviously, we're aware of the disposition that took place on September 23rd, 2025. And as you indicated, he served that day per day. I do want to put on the record, I know he's charged with larceny 6, and the allegation was regarding a pair of boots that he took out of the store. I just want to put on the record on behalf of my client, he did make a purchase, $125 pair of boots that he did return at some point, and then this incident occurred. I'm not disputing that this.
I wanted to return them and they wouldn't let
Yes.
me.
So there was a purchase though of the same amount of the boots. I just want to put that on the record on behalf of Mr. Roy. And it's, once again, as you indicated, the 30 days he received, he's already served that day per day. I'll speak a little bit more about his background at the appropriate time. Thank you.
So regarding that charge 1, I'm going to announce my findings. So I do find you violated conditional obedience to the law. This is based on your conviction of larceny 6. You see the sentence of 30 days jail. That concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, on behalf of Mr. Roy, I am respectfully requesting to have him reinstated as soon as possible. As we already put on the record, he did serve that 30-day stay per day. His parole officer's recommendation was to remain incarcerated until his court date is disposed of, which has been done. I'm showing, and hopefully this is correct, that my client was out in the community from, looks like he went to the halfway house on January 2nd, 2024.
He's been out 8 months and 22 days.
Okay. He's 50 years old. Upon his previous release, he did successfully complete the Renaissance Halfway House program in Waterbury. That looks like February of 2025 to September 2025. He was at the Connection Reentry, the REACH program in Waterbury, and he was there until he was remanded. As far as his education, he did report to us, he did obtain an associate's degree in construction at Lee College in Texas. And most recently, he was enrolled at Manufacturing Alliance Service Corporation in Waterbury. We studied CNN machining. He did complete approximately 6 weeks of the program, and then he got injured around the beginning of June. So he stopped the program, but he did report to us he did complete the classroom portion and was currently doing the shop part of the training. As a result of his injury, he does have some issues with his left foot, and then he has some surgery to remove some of the hardware in his foot due to a bone infection. And to go back to school, he needs to get doctor's note saying that he can stand for a minimum of 4 hours. As far as work history, has a relatively good work history. That letter that we submitted is from his current employer, hired Mr. Roy to do some construction at his house. Some photos were sent to me. I didn't think they were relevant as far as showing you what construction looks like, but we did get the letter where Mr. Merkhoffer indicated he's a business owner in Danbury for over 25 years. They hired Mr. Roy to paint the exterior of his house in Newtown. He's been working at the house for the past few weeks, painting and other handyman services. The exterior is approximately 70% done, and Mr. Merkhoffer has indicated to a significant other he will hire him back to finish those projects, hopefully when he's released at some point. And then the other letter we submitted was from Ms. Simpson with Mr. Roy's business card. Is that he does have Premium Painting Plus, his business where he does do painting for work. He did report to us. He did participate in clinical outpatient services at Wheeler Clinic in Waterbury. He also participated in IOP, biweekly individual psychotherapy with his clinician, Ms. Rowe, and received medication management also. Also participated in many meetings on Sunday mornings at Waterbury Hospital. He also reported to us he did some volunteer work doing property management at the Connection at the REACH program. He was obviously reporting to his parole officer with good regularity. That's not the basis of his violation here. He also reported to us to attend church in Chester. Since he's been incarcerated, he was on the wait list for AA and NA meetings. He would like to be placed at the halfway house in Waterbury again, and he's interested in utilizing that Sober Solutions halfway house once again. And he does want to return to the Manufacturing Alliance Service Corporation to finish that program that he started. As I indicated, he does have work still available to him by Mr. Merkhoffer, and he's amenable to all treatment recommendations. Raymond, anything I left out regarding your background, the way you do when you get out? We did file, and as I explained to you, we did submit this report. I don't need read it word for word, but she has a copy of it, and he does go through it thoroughly. So,
as far as the employer, the business he owns, my employer is called Coach Trim. He hired me as a full-time worker. He has 3 different properties in Connecticut. He wants me to be like a property management type deal with him in his business. And the project is 70% done. And the day I got remanded, I actually had material dropped off in his yard, and it's still sitting in his driveway right now. And once it gets too cold, it's not going to be able to be completed.
Yeah, and that's in that letter we submitted. Mr. Merkhoffer did indicate the 70% part.
Right. I just, I made a mistake. I made a terrible mistake. And, you know, it's my own fault. It's my own stupidity, and I take total responsibility for it. I just hope and pray that I get another chance to make it home. Also, my mother is not doing very well either right now. She has severe COPD with heart failure, and she's just on a downward spiral right now.
All right. Thank you for your comments, and just put on the record, you beat me to it. That was the last thing I was going to put regarding your mother. I did receive an email this morning from Ms. Simpson outlining that regarding your mom's condition. But when you and I spoke, you didn't really know what was going on. But according to Ms. Simpson, she did take unfortunately, a turn for the worse. But she did email me this morning. I just wanted you to know that. I know she wanted to make sure that information is relayed, but you beat me to it.
Right. I didn't know that she emailed you.
Yeah, she did. I just like literally a little while ago.
Okay.
So I don't have anything else to add. I think we put everything on the record we needed to.
All right. Thank you. I appreciate your comments. So I've reviewed all the evidence submitted by the state, and I've listened to testimony today. There's a few things that I will put on the record before I make a recommendation. As was previously stated, you were in the community about 8 months to 22 days before you returned to custody. You did receive a new 30-day jail sentence for larceny-related offense. You are on special parole for similar types of charges, including other larceny offenses. and you do a prior criminal violation on this period of special parole supervision. There were no misconducts received. Based on all the information I have, I am going to recommend that parole be revoked, that you be re-paroled for December 22nd of 2025. It's about a 3-month period confinement as sanction. I also recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, operation of a motor vehicle, mental health evaluation as deemed necessary, no contact with victims, LCJM and RC. My findings are going to the parole board on November 20th. So the board's going to review this recommendation. The board can let you out sooner if they like. They can agree to the recommendation, or they can hold you in longer. If they want to hold you in longer, we're going to let you know, and you're going to come back for a supplemental hearing, and the board will talk to you about reasons why they may want to exceed my recommendation. So just so you know, that is a possibility. You are on supervision until 2029. Do you have any questions?
No, ma'am.
You're going to get this in writing.
Question. You said September 23rd?
No, the board review date is November 20th. Your recommended release date is December 22nd.
December 22nd.
Yes, sir.
Okay.
So that's a recommendation. And so what the
Right.
board decides on the 20th, you're going to get it in writing from the parole board. So you'll have everything in writing what the parole board voted to do. So you'll have your release date as well as your conditions.
Okay, thank you.
Okay.
All right. Good luck to you. And if you want, Mr. Roy, if you can get a call into our office on Friday, the 22nd at around noon, one of my secretaries might be able to give you what happens over the phone, because we get an email first, and then the report is going to go out to you and myself about 7 to 10 days later. I know you're going to want to know if you're getting out on December 22nd. If you can call our office on November 21st, which is the day after the board reviews, one of the secretaries can give you the information over the phone if they adopted the recommendation. If there's an issue, if something odd happens where they reject it and there's going to be another hearing, obviously I'll set up a call with you and go everything with you. Hopefully that doesn't occur though.
Okay, thank you.
All right, good luck to you.
I appreciate
You're all
it.
set, sir.
Yep.
Take care. Have a good holiday.
You too.
Thank you.
Hey, guys, he'll be down shortly.
Thank you. Regarding the 9:45 time scheduled for Daryl Blatchett, At Cheshire, he will be heard, after McDougal at 10:45. Attorney Dean, are you there? Good morning.
Yes, hi, good morning.
So I wanted to let you know, I don't think actually it's not gonna affect you. This is your only case, I believe.
Yes, I think just this one.
Okay. So Corrigan should be here, yeah, shortly. Should be down.
Okay, no rush. Thank you so much.
You're welcome. Good morning,
Good morning.
Mr. Vasquez Flores.
Yes, correct.
So we're here today for your revocation hearing, have your attorney here, so we're gonna get started, okay?
Okay.
Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is revocation hearing concerning Vasquez Flores Felix, number 330982. Today is November 12th, 2025. This hearing is being conducted via video at the BOPP Central Office in Corrigan Correctional Center. This is a public hearing. Public access to the hearing is available via video live stream. Please state your full name and DOC inmate number for the record.
Felix Daniel Vasquez Flores, inmate number 330982.
You have counsel here today.
Yes, he had a deed on behalf of Mr. Vasquez Flores.
This is revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, responsibility to prove the allegations by a preponderance of evidence, that is. The better read evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, moving to release you and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
I do not.
You have important rights to have an attorney present. You have counsel here. You have a right to see the written notice of charges of violation. Did you receive the written notice?
I did.
You have a right to review the evidence. You have a right to submit evidence for your case. At the hearing, you have a right to call and examine voluntary witnesses and cross-examine diverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
All right, so we'll now review the charge the state your appeal is bringing against you and information underlying each charge. Charge 1, a release section absconder. Your charging officer reported at 9/9/24. You walked out the front door of Bishop House. You're only paroled through PCS residence without authorization. Steph attempted a verbal intervention by calling you back into the program, and you stated, "I'm leaving," and continued to walk down the street. Your whereabouts have remained unknown in the community, and you failed to contact Bishop House staff or your assigned parole officer. And the state filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT conditions of parole; B, halfway house agreement; C, Bishop House incident report; D, remand to custody order; E, parole violation notice; F, parole rights; and G is parole violation report. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes, I did.
And counsel filed the following exhibit that is pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue the hearing to obtain any additional evidence?
We do not. Thank you.
Okay, we have no witnesses today. So it's now defense's opportunity. If you'd like to present any evidence and speak to any of the evidence submitted at this time.
Yes, thank you. As to the absconder charge, I just want to note that this was a difficult situation. My client had been in the halfway house for about a year without issue and was doing very well there. He was working, he was doing programs in the community, and he hadn't had any tickets or misconducts while in the halfway house. Unfortunately, around September of last year, he reports becoming the target of harassment by one particular staff member at the halfway house. This harassment escalated. It became very inappropriate and made my client feel, unfortunately, very unsafe and uncomfortable there. I just wanted to kind of explain that because that is sort of the context surrounding the allegations here. And then at the appropriate time, we would just like to speak regarding his background and history. Thank you very much.
Thank you. All right, so what I'm gonna do next is I'm gonna announce my findings regarding that charge. 1, I do find you violate that condition or restriction of absconder based on a warrant being issued by the BOPP. The warrant was issued on 10/17/24, and evidence that was provided in support of the charge, which is exhibits A, C, and G. So that includes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Thank you very much. My client's 38 years old, born and raised in Waterbury. He does have a solid support system, including his fiance, his 3 sisters, his cousin, all of whom reside in Connecticut, in addition to many other extended family members and close friends. My client has 2 daughters, ages 20 and 15. He very tragically lost his oldest daughter earlier this year, which was a very, profound loss for him and continues to, stay with him until this day. Upon release to special parole in September of 2023, my client was placed at Bishop House, where he remained until September of last year. While at Bishop House, he was full-time employed at FHI in Cheshire for about 8 months. He also has employment history working with a tow company out of New Britain and also employment history tattooing, which he really enjoys. While at Bishop House, my client reports participating in a trauma group through Wellmore before transitioning to Connecticut Renaissance. He also was doing case management services with Project Longevity in Waterbury. He was assisting as well. He reports with a needle exchange program in the community. Since his remand, my client's been doing the phase 2 program for SRG at Corrigan. I will just note during a prior incarceration, he was SRG classified, which is what made him eligible for the program at this point, but there hasn't been any new situation that led to him being affiliated. That was from a prior incarceration, but he is, enjoying, I believe, doing that programming. Upon reinstatement of his special parole, my client is open to being placed at a halfway house in Waterbury. He wants to enroll in a trade school to study HVAC to further his career opportunities. He wants to return to that towing position out of New Britain and is open to all other recommendations, including returning to Project Longevity and reestablishing services at Wellmore. I am asking that you consider a sanction for my client not to exceed 4 months. He was in the community for about a year where he had been doing well, was employed, and was doing his programs. I didn't see any sanctions or misconducts reported during that period of supervision. And I do believe this is the first time he's been violated on this period of special parole. Sir, is there anything I didn't cover that you want to put on the record regarding your background or history at this point?
I mean, you pretty much covered it, but I would like to speak if that's all right.
Absolutely. Go ahead.
Well, I'm gonna swear you, if you want to speak, I just need to swear you under oath first, in the event. So can you please raise your right hand for me? You solemnly swear, solemnly affirm, as the case and be, the evidence shall give concerning this case, be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury.
I do.
All right, go ahead.
I take full responsibility for my actions. I know that, I did sign the agreements and I should have never left. That day, I did come back an hour late because I was actually considering not returning at all because of the situation that I was going through. But I pushed through and I decided to go, come back, be responsible. And when I came back, I went through another situation with the director. And that's why I left. It doesn't make it right, but I'm in a place where I'm supposed to feel comfortable, be helped, and I felt harassed, and I was not used to that. And being an adult male, it was a difficult situation. I was embarrassed. I didn't know who to turn to, and I did what I did, and I accept full responsibility for it. I was going to turn myself in. I ended up losing my 20-year-old daughter, and I'm grieving. To this day, I'm still grieving. So I just, I want to apologize for absconding the period, but I do take responsibility for my actions.
Thank you very much.
Thank you for your statements. Did you report it to anybody, this issue that you had? You didn't say anything to anybody at the halfway house or your officer? Nothing.
I did not.
So it probably would have been a better choice to do that, because you probably could have been moved somewhere else instead of this happening. And
I was just I was embarrassed. I've never, when I was younger, I was sexually harassed. I was molested. I'm a foster child, and I went through that. And to go through it again as an adult, I was lost. I didn't know what to do. I apologize.
so I'll be right with you with my recommendation. Right, so, I want to put a few things on the record, for this, before I announce my recommendation. This is your first violation of parole on this period of special parole supervision. You are on supervision for 10 years, until August of 34. So I'm going to say, I strongly encourage you, if you have any issues, to speak to your parole officer. Yeah, I don't, that's going to be the most important person you're going to talk to, because that's the person who's going to help you give you opportunities to do different things or move around, or that's the right way to do things. So I understand what you're saying, but I strongly suggest you work with your officer, so that you can remain on supervision, so you can complete this successfully, not come back here, and so we can keep you out there. Because you're never going to finish if you leave. You were out there about a year before you absconded, and then you were gone for about a year, until you were picked up by Waterbury police. So it's concerning that it took that to bring you back, because at any point you could have came in and came back, and we could have moved forward a lot sooner than this year. So that is concerning, but there are no misconducts received. I don't see any real written issues prior to this incident occurring. So based on all the information I have, I'm going to recommend that parole be revoked, that you be re-paroled for February 19th of 2026, approximately 5-month period of confinement at the sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, behavior management program for anger management, and mental health evaluation and treatment as deemed necessary. My findings are going to the parole board on November 20th. So I'm going to present this to the board. They can lessen the sanction as soon as 11/20. They can agree with my sanction of February 19th, or they can hold you in longer. If they want a longer sanction, you come back and have a supplemental hearing, and the board would talk to you about the reasons why they didn't want to exceed my recommendation. So just so you know, that is a possibility. You're going to get everything in writing from the parole board about a week after 11/20. You'll get it in writing what the board voted to re-parole you, the date, as well as your conditions. Do you have any questions?
I do not.
Okay.
Sir, if you would like to try and call my office the afternoon of the 20th, that afternoon, one of my secretaries should be able to let you know what happened, okay, with the board review.
Okay.
Thank you very much.
All right, so you're all set, sir. Wish you the best of luck.
Thank you. I appreciate it.
You're all set.
All right. Bye.
Thank you. Have a great day, everyone.
Have a good day.
Strange.
Good morning, Attorney Jones.
Good morning. How are you?
Good. Brooklyn didn't get the docket today, so they are working to get him down.
Okay.
So it's gonna be a few minutes.
Okay.
Thanks.
Thank you.
Yeah, go ahead, take a seat. Once you're all set in here, on your way out, just give a knock on the window, we'll let you out. All right. Sir. This one's set. Should I? Yeah, you're good. Thank you.
Good morning. Your side's just muted.
How's that? Can you
That's
hear
it.
us?
I can hear you now.
Okay.
Thank you so much. Mr. Smith?
Yes, ma'am.
Morning. I have your attorney here. We're gonna get started with your preliminary hearing, okay?
Yes,
Morning.
ma'am. Good morning.
Good morning. I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing, Attorney Smith Barden, number 344710. Today is November 12th, 2025. This hearing is being conducted via video at the BOPP Central Office in Brooklyn Correctional Institution. This is a public hearing. Public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Barden Smith, 344710.
You have counsel here today. Please identify yourself for the record.
Thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit.
This is a preliminary hearing, which the purposes of our Connecticut law is to determine if there is probable cause to believe you commit an act that violated the conditions of your parole, to determine if the act is sufficiently serious to warrant revocation of your parole, and to determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause or reinstate your parole, then release you and place you back on parole supervision. If I find probable cause and determine the act is sufficient serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding. Anything you say at this hearing can be used against you. This hearing is being recorded. This is the procedure for the hearing. I'm going to read you your rights. Then we will review the parole violation charge that your parole officer is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to address the issue of probable cause and the severity of the allegations. At the conclusion of this hearing, I will inform you my findings, which are based on the available evidence. Do you have any questions about the purpose or procedure before we begin?
No.
Okay. We have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice to charge of the violation. Did you receive the written notice?
Yes, ma'am.
You have a right to view the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Are you ready to go forward?
Yes.
We will now review the charge the state your PO is bringing against you and the information underlying each charge. Charge 1 of restructuring reporting. Your charging officer reported you were instructed to report on 10/20/25 between 9 a.m. and 12 p.m. in which you failed to do so. Charge 2, GPS. You failed to return home to your parole-approved residence for your 9 p.m. to 6 a.m. GPS curfew on 10/13, 10/14, 10/15, and 10/16/25. You had GPS shutdown on 10/16/25 from 6:08 a.m. until 12:02 p.m. and on 10/16/25, 10:32 p.m. to present. Charge 3 under curfew. Your charging officer reported you failed to return to your parole-approved residence from 9 p.m. to 6 a.m. GPS curfew on 10/13, 10/14, 10/15, and 10/16/25, which is in violation of your GPS agreement form. Charge 4 residents. Your charging officer reported you failed to return home to your parole-approved residence for your 9 p.m. to 6 a.m. GPS curfew on 10/13, 10/14, 10/15, and 10/16/25. On 10/20/25, your parole-approved sponsor reported that you had not been home to your parole-approved residence since 10/13/25. Charge 5 absconder. Charging officer reported you failed to report for your scheduled reporting on 10/20/25. You have not been back to your parole-approved residence since 10/13/25. Your sponsor reported that she has not seen you since 10/13/25. You have failed to contact this PO and your whereabouts are currently unknown. In the state is filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand of custody. B, parole condition. C, no civil violation. D, parole violation report. E, GPS agreement form. F, GPS curfew violations for 10/13/25, 10/16/25. And G is GPS shutdowns for 10/16/25. Did you receive notice of parole violation report, and those other documents I marked, or did you review them?
Yes.
You need to continue to contain any additional evidence.
No.
Okay, we have no witnesses today, so it's now defense's opportunity to like to respond and testify with respect to probable cause and severity of the allegations.
Yes, thank you. In regards to charge 4 under residence, we would submit there's insufficient evidence to support a finding of probable cause on this charge, as there is no evidence submitted that my client moved out of this residence, that he did not intend on returning to the residence, and that he was in fact living elsewhere. In regards to charge 5 under absconder, we would also submit there's insufficient evidence to support this charge. My client does maintain that he was in communication with his parole officer, that his sponsor did in fact tell him that his parole officer had come by and wanted him to contact her. He did in fact contact her, that his parole officer explained to him that his GPS monitoring device was not registering. She explained to him how to plug it in, push a button on the machine that would allow her to see his location. He in fact followed those instructions, and that she then responded to that location and picked him up from that location. So we would submit based on the fact that there's an element of intent that's lacking, as there's no evidence that my client was intentionally evading supervision as he was in contact with her. He's certainly available to testify as to that if you have any questions in regards to that. But he was picked up at the residence where she explained to him to plug in the device, push the button so that she could see his location. And then he was in fact then picked up at that location. So again, we would submit there's insufficient evidence to support that charge, as he was in communication with his parole officer. Nothing further as to the charges.
Thank you. Right, so I'll be right with you with my findings. Right, so I'm going to announce my findings. So regarding charge 1, I do make a finding of probable cause on release direction reporting based on evidence presented in support of the violation, which is exhibits B and D. On charge 2, I do make a finding of probable cause GPS based on evidence presented, which is exhibits B, E, and G. Regarding charge 3, I make a finding of probable cause on release direction curfew based on evidence presented, which is exhibits B, E, and F. Regarding charge 4, condition residence, I make a no finding of probable cause based on there being insufficient evidence to support this charge, as well as testimony. And on charge 5, condition absconder, I make a no finding of probable cause based on there being insufficient evidence to support this charge, as well as it not meeting all the elements. And this is also due to testimony that was provided. I do find the act serious enough to warrant revocation. I think you should detain while you wait for revocation hearing. At the rev hearing, myself or another hearing examiner will determine if you violate the conditions of your parole. If so, the hearing examiner will make recommendations regarding whether your parole should be revoked or any sanctions to be imposed. So to bring you back, it's technical violation. So we have 60 business days to schedule your rev hearing upon your return to custody. So we will schedule you for that, and you'll come back, and then we'll determine what happens moving forward. Okay?
Yes, ma'am.
And I'll be in touch with you as soon as I have that date so we can go over things again, okay?
Thank you, Ms. Jones.
All right, you're welcome. Thank you.
Thank you.
Right.
Yeah, so you read it and they'll come on in a minute. Sorry.
No, perfect. Glad it worked. Good morning, Mr. Maldonado.
Good morning.
Morning, we're gonna get started with your hearing, okay?
Okay,
Good morning, I am P.O. Meissner, hearing examiner for the Board of Pardons and Paroles. Revocation hearings for Maldonado Elevator number 390-833. Today is November 12th, 2025. This hearing is being conducted via video at VOPP Central Office in Osborne Correctional Station. This is a public hearing, public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Eliabner Mercedes Maldonado, 390-833.
Thank you. We have counsel here today. Please identify yourself for the record.
Good morning, Peter Matthews with the Public Defender's Office for Mr. Maldonado.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, release you and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge, state your parole officers bring against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all of the evidence presented, I will announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, I would like to know what is it that you consider for the preponderance of evidence? What do you consider valid to satisfy or meet the requirements of preponderance of evidence?
Preponderance of evidence basically means, in a legal term, more likely than not. So it would mean the evidence is more likely than not. It's basically the legal standard for preponderance of evidence.
So a testimony from a person given on a document is produced illegally. Her testimony on the paper, is she here first of all? Because I asked for LaRonda Winfrey, P.O. Reeves here. Are they here?
They are not, Mr. Maldonado. We did try to get in touch with Ms. Winfrey and the other Ms. Sinkar. They were not, they no longer work at that halfway house. We were able to get in touch with them, so they are not here today. We also left a message for your parole officer indicating that you were hoping she'd be present today, but again, I cannot make her appear today.
Okay. So you have important rights today, right to have an attorney present, you have counsel here. You've received the written notice of charges, the violation. Did you receive the written notice?
Yes, I did.
Okay. You have a right to view the evidence. You have a right to submit evidence in support of your case at this hearing, right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we will now review the charge, state your falsehoods bring against you, and information underlying each charge. I will note that no finding was made at the time of the preliminary hearing on charge 2, part 3, so that is not taken into consideration today. So there's charge 1 under bail laws, obedience to the law. Your parole officer reported on 5/9/25. Staff were in the process of beginning room searches. Staff arrived in front of your room, and so you were standing in front of your bed, taking something out of a black bag. You were instructed by program manager Winfrey to put the bag down and exit the community room. You started getting argumentative and were asked to put the bag down and go with staff member Cecil to the community room. You placed the bag down and walked to the doorway. You then turned around and grabbed program manager Winfrey's wrist and twisted an attempt to get her to drop the black bag. Consequently, due to your actions, state police were called, ultimately charged you with assault, third, and disorderly conduct. Charge 2 under additional conditions, halfway house placements. There's part 1 and part 2. Part 1 states on 1/31/25, around 15 p.m. Staff smelled strong marijuana odor by your room. Staff entered your room, asked you to go to the community room, to which you complied. Staff entered the room search and located marijuana inside a plastic bag located under some clothing inside of your dresser. You also found a joint on top of your dresser. And part 2 states on 3/10/25, you reported to the front office around 11:50 a.m. requesting your community pass to Walmart. Your pass start time is approved for 10 a.m. You became very agitated, saying that you were going to use your pass at 12 instead. It was explained to you that you cannot change your pass time without approval. You became increasingly agitated and followed the program manager to her office, stating, "Do you know who I am? I'm on special parole." You continued to speak very loudly and would not lower your tone when asked. You were told to go back to your room, in which you didn't. Program manager Winfrey contacted state police to intervene. And the state has filed the following exhibits that were labeled Exhibit A to Exhibit S. And these are the same ones that are put on the record.
On Exhibit J, you didn't finish. It said that she could hear me talking loudly on the hallways. On Exhibit J, you only stopped right there. PM Winfrey continued to work during the phone call in his office. She said that she could hear me talking very loudly on the hallway.
We have all that evidence. She was just.
I'm just putting evidence on the record.
And then the police was called. Right after she heard me talking loudly on a phone call in the hallway, she called the police.
All right, Mr. Mullen, when I'm done speaking, you're gonna have a chance to address the charge as well, okay? Let's get this process started here.
I'm just putting what's on the record for the evidence that was submitted by the state.
It is on the record. It's Exhibit J.
You know, this is part of the process. You need to let me do the process. I'm going through the process right now. So I'm putting on the record that the evidence received by the state was Exhibits A through S, and these are put on the record at the time of the preliminary hearing, and there's no changes to any of this. And the state did note that it had received all this evidence, correct?
Yes, we did.
Okay, then it was reviewed.
Yes.
Okay. So council has filed the following exhibit that was pre-marked for identification purposes. We have Defense Exhibit 1, which is Roger Sermonhouse Client Infraction Report. Do you need to continue the hearing to obtain any additional evidence?
I do not.
Okay. We have no witnesses today, so it's now defense's opportunity. If you'd like to speak to any of the evidence submitted at this time?
Yes, I would. Thank you. So with regard to charge 1, the obedience to the law charge, these charges were not pursued in court. The charges were reduced to an infraction, which is not a criminal offense. Based upon this, I'm going to ask for a no finding with regard to charge 1. At the time of the arrest, based upon the statements and police reports, there may have been probable cause to pursue the charges then. However, the prosecutors in court, after investigating and reviewing the evidence, came to the conclusion that the criminal charges should not be pursued and elected to reduce the charge for non-criminal infraction. Mr. Maldonado has adamantly contested these charges from the very beginning. The prosecutor had an opportunity to review the video evidence, which, according to the report in Exhibit S, was not very helpful to the state in proving their case. Simply because someone is arrested for an offense does not mean that there's a preponderance of evidence that they're guilty. And based upon the result in court after this case is evaluated, I believe there should be no finding as to charge 1. With regard to charge 2, I will start with the marijuana found in the room on January 31st. Again, as I indicated at the preliminary hearing, Mr. Maldonado did not have exclusive possession of the room. It was shared with roommates. It was not found in actual possession of any marijuana. It was found on and in a dresser. As I indicated previously, I would further note Connecticut General Statute 54-125K, which specifically states that possession of marijuana should not be grounds for revocation of parole absent an individualized finding that the use of cannabis would pose a danger to the person or the public. There's no evidence that this condition has been met in this case. Therefore, the marijuana possession should not be a basis for his parole revocation. I will also note that Mr. Maldonado contests the allegation that 2 staff members were present in this room when it was searched, as is required by the halfway house rules. Neither of these witnesses are available, work there anymore, and nobody's available to provide any additional testimony.
And it was not 2 staff members. It was not 2 staff members. It was only
Mr. Maldonado.
I have to swear you in before you can speak, so please do not speak yet. Okay, go ahead.
Finally, regarding the incident on March 10th, the disruption here appears to be minor. No arrest was made. I know the police may have been contacted, but they chose not to pursue any action. After the report, Mr. Maldonado the allegation Mr. Maldonado was speaking loudly while walking the hallway after being told he did not use a pass. He didn't threaten anyone or engage in any type of criminal conduct. It doesn't appear there's sufficient evidence here that he treated anyone with disrespect and didn't engage in any physical or verbal altercation. He was upset and briefly he was a little too loud, is what the allegation was. No one was threatened. I don't think there should be a finding on this charge either. if there's a finding on any of these charges, I would like to be heard again regarding the sanction. I believe Mr. Maldonado would like to address some of these charges as well. Is that correct?
Absolutely.
All right, so can you please raise your right hand for me? You solemnly swear, solemnly, sincerely affirm, as the case may be, the evidence you shall give concerning this case be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury.
Like always, yes, I do.
Okay, go ahead.
Since January, when I got to the halfway house, I've been addressing issues informally, like it is required for me to do, with no positive results whatsoever. When I decided to start reporting the incidents that I saw that were not right, all I received was retaliation from the halfway house staff. To the point that I couldn't even speak loud on a phone call because she calls the police on me. Because I'm talking loudly on a phone call. Maybe I wanted her to hear what I was saying so she can understand that it was illegal, all the stuff that she was doing. Maybe she felt threatened, and that is why she called the police on me when I was on the phone call. I know what I was saying on that phone call. I was talking to, and I wasn't talking, I think I was leaving a message to the connection, Kathleen Eldridge, on her voicemail, because she stopped talking to me too. She stopped picking up the phone calls after the grievances, after everything that I was doing that is required for me to do to address issues the healthy and correct way. They knew I was right, but everybody ignored me. So as you can see, all this evidence that was introduced by Winfrey, it is frivolous, it was malicious, to the point that she even broke the statutes of Connecticut, general Connecticut statutes, to get me in trouble. She lied to the police. She signed a document, the residential discipline report. I mentioned this on my preliminary hearing. This is a government instrumentality, is called according to the statutes, 53A 139. She signed on both because nobody wanted to sign these lies. So she signed for the staff member and the supervisor. This is forgery, according to Connecticut general statutes. So why, every time I try to address issues, all I get is retaliation and get put back in prison, lose everything that I was doing, because I worked 61 hours that week that I was remanded from this incident. 61 weeks. I wanted to ask my parole officer what she says that she saw criminal thinking and criminal behavior. I got to that halfway house on January 2nd. On January 8th, I was already working. I was already working in January 8th.
We talked about a lot of this at the prelim. I understand that. Do you have anything new you want to add to those remaining charges? Because
the remaining charges are that's what I'm talking about. The exhibit J, that I was loud on the phone and she called the police on me for me being loud on the phone call. And I'm talking about exhibit K on the comments the parole officer made. I wanted to talk about that because I told her what was going on. And I told her what was the issue in that halfway house, just like I told the connection. And look what happened. I've been 6 months in prison for what? For me speaking up, for letting them know, hey, what's going on? Why didn't they take it as constructive criticism and they took it as a threat and let me put them in prison? Because that's the way it looks. Okay.
So is there anything new that you just want to add to these? If not, we'll move forward. I have noted what you said at the prelim. I have noted everything your attorney has stated. We have the court's disposition of the infraction. So, I mean, if there's nothing new, we can move forward.
Let's move forward.
Okay. So I have noted, like I said, I noted everything you said. So what I'm going to do is I'm just gonna also put on the record, in regards, I did receive that addendum that states on 10/2/25, those charges were subbed to creating a public disturbance with a $75 fine. So I do have that information.
And I want to add, the only reason why I pleaded guilty to causing a public disturbance, I didn't know that it was, the word public was there. My lawyer just said, causing a disturbance, because I can understand that it can be disturbing. Of course, if I have a position and there's somebody that I believe is underneath me pointing out my wrongdoings, I believe that can be disturbing. And that's why I said, you know what? I may have caused a disturbance in their mind because I'm pointing out wrongdoings that they need to fix. Yes.
Okay, so I noted that. So what I'm gonna do now then is I'm gonna announce my findings in regards to those leftover charges that I have. So regarding that charge 1 obedience to the law, I make a no finding. Due to there being insufficient evidence to support the charge is also sub to infraction, creating a public disturbance. There's insufficient evidence to support the what was stated in the behavior. Charge 2, I do find you violate condition halfway house placement. Part 1, based on exhibits D, E, H, F, I, J, and K, and that's part 2 as well. Part 3 was not taken into consideration. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, please. So Mr. Maldonado, he's 51 years old, was born and raised in Puerto Rico. When he's released, he's looking to reside in the New Haven area. Prior to his remand, he was working at Chili's on a full-time basis. He had also recently completed the Emerge Employment Training Program. He's also obtained his forklift and his OSHA 10 certifications. When he is released, he's very anxious to find employment, get back to work. He's hoping he can get back to work doing the same kind of things he was doing before his remand. With regard to the sanction, I do think the fact that there was no finding on charge 1 should be certainly considered here. The only finding was partial finding on charge 2 is the extent of this violation at this point in time. He has not been convicted of any additional criminal conduct. There was a small quantity of marijuana found in his room in one instance where he allegedly put that and loud in the hallway. That's the extent of these violations. He has been remanded now for 6 months. I understand Parole was recommending a 1-year sanction. However, given the no findings that have been made, I would ask for Mr. Maldonado to be released at the next available date. I know he's had some difficulties with the staff at the Roger Sherman House, but he does understand he needs to cooperate with halfway house directives, the requirements for his parole officer. He has about 1 year of supervision remaining. This was a 7-year period of separation parole, and this is only a second violation. So I do think he has demonstrated an ability to cooperate with parole directives for some lengthy periods of time over those 7 years. Since his remand, he's been cooperative with corrections. He hasn't picked up any tickets, and he's anxious to get this behind him, get back to work, and complete the sentence successfully. Thank you.
And you said halfway house New Haven area.
New Haven is where you want to go,
Yes.
correct, Mr. Maldonado?
And
Yes.
work was done in like restaurant work.
I was working actively at Chili's when I was remanded. I'm gonna reapply just because it's been 6 months. So I have to reapply and start the whole process again.
Okay.
Every time I have a plan, that's another thing. Every time I make plans for the future, somehow somebody finds how to ruin those plans. And it's how society ruined my plans.
Well, so I noted everything that was stated. As we can see, there were no findings made today. I am going to just put a few things on the record before I make a recommendation. You were in the community about 4 months before you returned to custody. You did receive an infraction with a fine. You do have 1 prior violation of parole. I received 2 misconducts that were received. Based on the information that I have, I am going to recommend that parole be revoked to be reparoled for November 20th, 2025. This is about a little over 6-month period of confinement as a sanction. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, behavior management program for anger management, No contact victim MS, JS, and MT, and mental health eval and treatment deemed necessary. This is my next board review date that I have available. So if this gets approved, you'll be released on November 20th. You'll know that the board agrees with me because you'll be released that day. If you stay longer than 11/20, that means the board disagreed with me and that they want to talk to you. So that is an option, you know.
I would
if
like
you
to
wanna
talk to them.
Well, that's just a possibility that, I'm not saying you're coming back. I'm saying I'm recommending 11/20 release. If the board disagrees with me for whatever reason, they'd like to hold you in longer, then you come back for a supplemental hearing and the board would ask you questions. So you'll know that day, if you go or not, if they agreed or not. Is there anything else?
No, nothing else. So that's the date, November 20th, unless the board wants to hold you for longer, it looks time to get another hearing. That'll be the date you'll be released.
Okay,
And I will be released to New Haven, right?
I put New Haven, yes.
Okay, and if I'm released, how can I get in contact? Can I get in contact? I would like to speak. I would like to know who the board members are, and I would like to speak to them because.
Well, you don't speak to them. You're not going to the pro board. No, if they agree with me, you're released that day. There's no other further process. So you're all set
Okay.
for today. That's the end of revocation hearing. So best
Okay.
of luck, sir.
Thank you. Have a good day.
Well, good luck.
Bye.
Mr. Capio?
Yes, ma'am.
Oh, good. Okay. Making sure it's you. I can't really see. Oh, there it goes. Oh, it zoomed in now. I can see. We'll get started with your revocation hearing in 1 minute, okay?
All right.
Good morning. I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Parole. This is a revocation hearing, Attorney Ocasio-Freddy, number 288489. Today is November 12, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougall-Walker Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Ocasio-Freddy, 288489.
We have counsel here today.
Sure. Attorney Alfonso Sirica from the Parole Revocation Unit, on behalf of Mr. Ocasio.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole, which is releasing you and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge. State your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, this counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights. The right to have an attorney present. You have counsel here. You've received the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to review the evidence. You have a right to submit evidence in support of your case at this hearing. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
Okay, we will now review the charge, the state your officers bringing against you, and the information underlying each charge. Charge 1, obey laws of being in law. Your charging officer report on 6/11/25. Harvard Police Department investigators, detectives executed search warrants on residents you were associated with in your vehicle. Upon making entry into the first floor apartment at 7880 Douglas Street, officers recovered the following from inside of the target apartment: $7,700 in U.S. currency. Seized as suspected drug proceeds. A stitch bag containing approximately 3,200 yellow wax paper sleeves, each containing a white powder-like substance to be fentanyl. 1 Newport cigarette box containing approximately 45 purple wax paper sleeves and 30 yellow wax paper sleeves, each containing off-white powder substance suspected to be fentanyl, in 2 clear knotted plastic bags, each containing a white rock-like substance, 2.9 and 0.9 grams, suspected of crack cocaine. 1 self-sealing sandwich bag containing 6 clear knotted bags, each containing a white rock-like substance, suspected to be crack cocaine, weighing approximately 82 grams. 1 CR digital scale, 1 razor blade, and 1 plate, all covered in a white powder residue. 1 suspected drug ledger with a list of names and numbers, and 1 box of empty plastic sandwich bags and suspected drug packaging material. Upon completion of the search, and the scene was cleared. The Nissan Altima that was parked in front of the residence was searched. No items of evidentiary value located. Portions of suspected fentanyl and crack cocaine were later subjected to narcotics identification kit tests, both which test positive for their suspected narcotic substance. You were served this warrant while at Hartford District Office, where when you were remanded during the execution of the warrant, you acknowledged full ownership of all illegal drugs in the apartment. Subsequently, you were charged with and placed under arrest for violation of Connecticut general statutes, illegal possession of narcotics, illegal possession of narcotics with intent to sell. Charge 2, drugs. Charging officer report on 6/11/25. HPD and investigators, detectives executed search warrants on residents you were associated with. You were found to be in possession of approximately $7,500 in cash, drug proceeds, 3,500 bags of fentanyl, 85 grams of crack cocaine, 1 digital scale razor blade, and plate covered in a white powder-like residue, and 1 suspected drug ledger with a list of names and phone numbers. Subsequently, you were placed under arrest in charge with illegal possession of narcotics and illegal possession of drug narcotics with intent to sell. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, signed statement of understanding agreement conditions of parole. B, remanded custody order. C, violation notice of parole employee rights. D, parole violation report. E, state of Connecticut judicial branch pending case detail. F, HPD incident report case ending in 9440. G, BOPP decision information summary. And H is signed search and seizure warrant. Did you receive notice of parole violation report, and those other documents I marked, and did you review them?
Yes, ma'am.
Okay, and counsel file the following exhibit remarked for identification purposes. Defense Exhibit 1, which is list of parole accomplishments and future plans for parole reinstatement. I did receive the addendum from PCS. The addendum reported at 9/29/25. You were convicted of possession of intent to sell narcotics to the 1-year jail sentence with the other charges nollied. I have a TS date of 12/6/25 and an EOS date of 6/7/26 currently. And we have no witnesses today. Is there any additional information?
No.
So it's not a defense's opportunity, but to speak to any of the evidence submitted.
Yes, the first part of the hearing, to be brief, you have the disposition from court. That is the correct disposition. My client's been incarcerated since June 11th of 2025. He was out for approximately 2 years, and this seems to be the only issue he's had while on supervision. I'll cover that a little bit more at the second part of the hearing, but we had the disposition from court, so I don't have much to add regarding the first part of the hearing.
So what I'm going to do next is I'm going to announce my findings. So regarding charge 1, I do find you violated conditional obedience to the law based on your conviction, possession with intent to sell, dispense narcotics, and see sentence of 1 year jail. And charge 2, I do find you violated conditional bail laws drugs based on evidence that was provided in support of that charge, which is exhibits A, D, and F, as well as the conviction of criminal possession with intent to sell narcotics. That concludes the fact-finding portion of this hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, on behalf of Mr. Ocasio, as I indicated, my client was up for approximately 2 years. He's 50 years old. In the narrative from his parole officer, it indicated he'd been on supervision out in the community. And there has been no issue. He's been compliant with his conditions. He did provide verification of his employment, was working at the last parking as an attendant. And I'll get into that a little bit more. My client, as I indicated, he's 42, born and raised in Hartford. He does receive support from his 2 brothers, Juan and Orlando, and his 2 nieces. He has 2 children, aged 23 and 11, and he does have 1 granddaughter. On his previous release, he did successfully complete the Community Solutions Halfway House program in Hartford. Then he was sponsored by his son, Mr. Ocasio Jr. in Hartford. He was there for approximately 6 months, and then he moved downstairs with his brother. He did obtain his GED in 2001. As I already indicated, he had a full-time job with Last Parking as a parking attendant in Hartford. He began that job where he was at the Watkinson House and was employed there until he was remanded. While he was at the Watkinson House, he did attend the Project Safe Neighborhood, and it looks like in January of 2025, he did successfully complete Relapse Prevention Group, SCRT, in Hartford. Since he's been incarcerated, he did get a job as a chairman, which is a 7 days a week position. And I know the parole officer indicated he wanted him to complete voices. He did sign up, unfortunately, was put on the wait list at the facility. Upon his reinstatement, he'd like to be sponsored by his brother, Mr. Juan Ocasio in Hartford. I provided you with the phone number and address, and he's amenable to any treatment recommendation. Unfortunately, this incident occurred, but it indicated it appeared my client was compliant for approximately 2 years. He was reporting to probation. He was providing his job verification to his parole officer. Mr. Ocasio, anything I left out about your background? Anything you want to add about what you're going to do when you get out? Is your opportunity if you want to add anything.
Just try to stay on the straight and narrow this time for sure and get back to work. My job is still waiting for me at last right now, as soon as I get out.
And your parole officer did indicate, it's already put on the record, you were compliant up until this incident occurred. You were doing everything you were supposed to be doing.
Yes, I was.
Thank you.
Thank you. Thank you for your statement. So I've listened to testimony today. I have reviewed all the evidence provided by the state. There's a few things I'm going to put on the record before I make my recommendation. Yeah, it says you were in the community about 1 year and 10.5 months before you were returned to custody on this new charge. in which you did receive a new 1-year jail sentence. There are no prior parole violations. You did receive 2 misconducts that were around drug use. Are you still involved in treatment for substance abuse?
Nah, I'm on the waiting list for the voices in here. That's about
Do you
it.
plan on doing anything in the community to address that, or?
Yeah, I don't mind doing a relapse prevention as soon as I get, if I was to get out, do any drug program.
Were you doing anything in the community before you came back?
I had just finished the one that he said in January of this year. That was it.
This year, he did. He
Okay.
completed one in January.
Okay.
That was the
Where was that?
the relapse prevention group, community renewal, CRT
CRT.
in Hartford, yes.
So is that where you do all your treatment in Hartford through CRT?
Yeah, that's where I've
Okay.
mostly been going. Yep, on Market Street.
Okay. Right, so your officer did recommend a year incarceration. You are in supervision until the summer of 2028, so you still have some time. Based on the information I have, I am going to recommend that parole be revoked to be re-paroled for June 7th of 2026. It's about a 1-year period confinement as a sanction. This is the EOS date on the new conviction that you received. I am going to recommend the following parole conditions: no consumption of alcoholic beverages, operation motor vehicle, and a general no contact with AS. Sure I have. One sec. Those are my recommendations for conditions. But I'm going to forward this to the parole board for November 20th. The board is going to review my recommendation, as well as all information regarding this hearing, and they're going to vote on whether or not they would like to keep the recommended date I provided. The soonest date for you was 12/6/25. That's the soonest you could be let out. And the board can also hold you in longer than the date I've recommended. So you'll get that in writing about a week after, November 20th, what the board's final decision is. So you'll see the date that they gave you as well as the conditions. If it's longer than what I've recommended, you would come back and have a supplemental hearing, and the board would talk to you about reasons why they may want to exceed my recommendation. That's if they choose to do that. Do you have any questions? Do you understand?
So you recommended June, right?
Yeah, your EOS date on that new sentence is June 7th.
Okay.
Okay?
So Freddie,
No
it's going to the board on November 20th, about 7 to 10 days. You get a copy of the report, I get a copy of the report. There's an issue with that June release date. I will set up another call with you if you, I'll call you, you can call me, but hopefully they adopt the recommendation, okay?
All right, thank you.
All right. Good luck
Okay,
to
you're
you.
all set, sir.
Thank you.
Good day.
You too.
Oh.
Thank you.
Good morning, sir.
Good morning, ma'am.
I'm just waiting for your attorney to come in here, and then we'll get started, okay? Oh, there he is.
All right, ma'am. Good, yourself?
Good. All right, so we're here today for your revocation hearing,
Okay.
so we'll get started with that. Good morning, I'm Theo Meisinger, hearing examiner for the Board of Pardons and Paroles. It's a revocation hearing concerning McGuire James, number 392951. Today is November 12th, 2025. This hearing is being conducted via video at the BOPP Central Office in McDougal Walker Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
James McGuire, 392951.
Thank you. Counsel here today, please identify yourself.
Good morning, Peter Matthews with the Public Defender's Office of Mr. McGuire.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinements. So this is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state your parole officers bring against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present our relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. Right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, ma'am.
Okay, you have a right to view the evidence. You have a right to submit evidence for your case at this hearing. You have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights? Are you ready to go forward?
Yes, ma'am.
All right, so we'll now review the charge the state your officers bring against you. Any information underlying each charge. In charge one or release direction GPS. The charging officer report on 3/27/25. The offender signed the GPS monitoring agreement in which he agreed to not damage or tamper with the GPS tracking device, strap, beacon, or charging cable on 8/4/25 at 12:19 p.m. There are 2 strap violations indicating the offender damaged the strap. On 3/27/25, the offender signed a GPS monitoring agreement in which he agreed to ensure the GPS tracking device maintains signal with GPS satellites by promptly moving outside or to another area where signal can be acquired unless otherwise directed by a parole officer. On 8/4/25 at 2:50 p.m., the offender failed to ensure the GPS tracking device maintained signal with GPS satellites by taking such actions, resulting in the GPS unit being unable to connect. The unit was never able to reconnect, and the offender did not have permission from his parole officer to neglect taking these actions. Charge 2 under restriction curfew. Charging officer report on 3/27/25. The offender signed a GPS monitoring agreement in which he agreed to follow an established curfew to be at his parole-approved residence from 8 p.m. to 6 a.m. daily. On 8/2/25 and 8/3/25, the offender did not stay at his parole-approved residence, violating his established curfew. Charge 3 under avail laws of obedience to the law. Charging officer report on 7/25/25, a female victim gave a statement to the Groton PD. She stated the offender is her ex-boyfriend and he called her work 3 times and her cell phone 35 times. On 7/24/25 between 11:32 p.m. and 11:58 p.m. and 10 times on 7/25/25 after she told him to stop calling. The victim said the offender told her he doesn't care if she gets a restraining order. He will make her life a living hell and burn down her apartment and car. Subsequently, the offender was charged harassment second and threatening second physical threat. On charge 4 under behavioral management program, your charging officer reported on 4/24/25, the offender attended an intake for Explore, at which time the offender was instructed to report for Hart Street in Britain, Connecticut every Tuesday at 7:30 p.m. starting on 5/6/25. On 5/20/25, the offender did not attend as required and received an unexcused absence. The state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT conditions of parole, B, remanded to custody, C, notice of parole violation, D, parole violation report, E, GPS monitoring agreement, F, arrest warrant, G, misconduct, H, event history, I, Explore report, J, email, RE, Explore schedule. Did you receive notice of parole violation report, and those other documents I marked? And did you review those?
Yes, ma'am.
And counsel has filed the following exhibits that are pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. And Exhibit 2, which is a support letter from Ms. Robinson. Do you need to continue the hearing to obtain any additional evidence?
I do not.
Okay, we have no witnesses today. I will put on the record, I received The addendum from PCS. The addendum reported on 10/2/25, you were convicted of threatening second, received 8-month jail sentence with all their charges nollied. And the EOS date on that sentence is 4/1/26, with the TS date being 12/1/25. So is now defense's opportunity like to speak to any of the evidence submitted at this time?
Thank you. So that is correct with regard to the criminal conviction for threatening in the second degree. Mr. McGuire did enter a plea on October the 2nd and received an 8-month sentence. I will note he still does contest the allegations. However, given the remand status, unfortunately, there was a lot of incentive for him to accept this offer rather than dragging out the pending case and potentially taking those charges to trial, which can take a long time. So he did plead guilty, but he does want the hearing examiner to understand that he does contest these charges. Turn to charges 1 and 2 pertaining to the GPS. I will note Mr. McGuire did not remove the GPS. These violations allegedly occurred 2 days prior to him turning himself into the police on the outstanding warrant. At this time, he was attempting to reach his parole officer regarding what he should do with the outstanding warrant. He was staying with his fiance at this time as he was anticipating the need to turn himself in, and he didn't have transportation to turn himself in while she did possess a vehicle. He wasn't able to get in touch with his parole officer over the weekend, but he did eventually speak to an attorney who did advise him to turn himself in, and he did turn himself in right away after speaking to the attorney. He turned himself in on that Tuesday morning. So while he was awaiting guidance on what to do about these warrants, he was unable to charge GPS for a period of time. But I will note he had been under GPS supervision since March and had been completely compliant with the GPS supervision for this period of time up until those 2 days before he turned himself in. There's no indication there was any prior GPS violations or failure to keep it charged in any manner. Finally, with regard to the missed Explorer class on 5/6, he only missed 1 session. I know on the Explorer program, I believe it takes 4 sessions before you're discharged unsuccessfully for the program, so he still was in the Explorer program. I did review Exhibit I, which does provide evidence that otherwise he was doing very well in the Explorer program. He was participating, and the supervisor had very positive comments about his progress in that program. After that 1 missed session, he appears to have had perfect attendance in that program up until he was remanded in August. So if there is a finding, I would like to be heard further in regard to sanction. Thank you.
Thank you. Right, so I have noted what was stated testimony. I'll be right with you with my findings. All right, so I'm going to announce my findings. So regarding charge 1, I do find that you violated condition GPS based on evidence provided, which is exhibits A, E, and H. On charge 2, I do find you violated condition curfew based on evidence presented, which is exhibits A, E, and H. Regarding charge 3, I do find you violated condition obedience to the law. This is based on your conviction of threatening second and received a sentence of 8 months in jail, as well as exhibits that were provided A, D, and F. Regarding charge 4, condition behavior management program, I make a no finding due to the charge not meeting the elements, as well as testimony that was in support of that. This concludes the fact-finding portion of this hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. The purpose part of this hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, please, thank you. So Mr. McGuire is 44 years old. He was born and raised in Massachusetts. He has been residing in Connecticut since his release from incarceration. When he was initially released from incarceration, Mr. McGuire did reside in a halfway house. He was doing well there, and he then transitioned to a reach bed for a period of time. He and his fiance have recently purchased a home in Windsor Locks, and he's looking to reside with her and be sponsored by her at their home when he is released. There are no children in the home. It would only be Mr. McGuire and his fiance. He doesn't have any other family in Connecticut. His fiance really is his sole source of support, and they have a very close relationship. It's very supportive of him. She did provide a letter in support of Mr. McGuire that was marked as an exhibit. Prior to his remand, Mr. McGuire was working in the construction industry. Right before he was reincarcerated, he did have a job offer at Rich's Food Warehouse. This was a full-time warehouse position, and Mr. McGuire is hopeful he'll be able to reinstate that job opportunity when he is released. He did recently obtain his OSHA 10 certification. He got his driver's license and his forklift certification, and these licenses and certifications will be helpful with him to his career going forward. He has a good work history, including other warehouse positions for a period of time at AutoZone, and he's always been able to find and maintain employment. That's always been something that he's taken very seriously. Mr. McGuire did graduate from high school. He has an associate's degree in business management. He is a military veteran. He was in the Marines for 10 years and deployed in Iraq. And according to the DIS report, he was discharged from the military after he was shot in the leg. So Mr. McGuire was previously discharged from the Department of Corrections on October 30th of 2024. He was under supervision a little over 9 months prior to this remand. Other than that one missed Explorer class, it appears like he was doing very well with treatment through parole over the 9-month period of time. I didn't see any other missed appointments or positive drug tests or anything of that nature in the PBR. He was attending counseling through the Wheeler Clinic. As I indicated previously, the Explore report indicates he was doing very well with the Explore program. And Mr. McGuire did indicate that he was taking drug tests when requested by parole, and they always came back negative. He's also engaged in extensive treatment with the Connections program over the course of parole, and the treatment notes there also indicate he's complied with that treatment and was doing well with that program. He was reporting to parole. He was complying with the GPS supervision up until that weekend prior to turning himself in on the warrant. He did voluntarily turn himself in on these charges. He never cut the GPS or absconded from supervision, despite being aware of the remand based upon this misdemeanor warrant. So he turned himself in and he faced the charges, even though he knew he was likely going to face some incarceration based upon it. As I indicated, Mr. McGuire, he does disagree with the allegations and the arrest warrant that were served on him. That being said, he does have a very poor relationship with the complainant and understands that it's in his interest to make sure they don't have any contact going forward. Even if she reaches out to him, he's the one who's on parole and he can't risk any further violations of this nature. As I indicated previously, all the charges in the warrant, including the one charged into the plea to, were misdemeanors. There was no allegation of any physical contact between the two individuals. I understand this is a third violation of supervision, and his parole officer had made a recommendation of 12 months incarceration. I would ask you to consider something in the 6 to 8 month range, which is more in line with what he received as a sentence in court. Mr. McGuire, he has a lot of potential. He's a hard worker. He's been making strides to comply with parole and rebuild his life. And that's what he wants to do going forward. He understands having any contact is going to be detrimental to him. He's assured us he's not going to do that. He just wants to move on with his life and try to turn things around. Mr. McGuire, is there anything you'd like to add?
No, not at this time.
Right. Thank you. So I'll be right with you with my recommendation. I do want to know there is a extraditable BOP detainer in Massachusetts, which I'm sure you're aware of. So just so you know, whatever re-parole date you're given, whatever, you would parole to your Massachusetts detainer first, resolve that, and then you would move forward with your plans, just so you're aware of that. Right, so there's a few things that I'm going to put on the record before I make my recommendation. You were in the community about 9 months before you were returned to custody on these new charges in which you received a new conviction that is related to domestic violence, and that new 8-month jail sentence. You do have 2 prior violations, as was noted, on this period of supervision, a criminal and absconding with charges that were both related to domestic violence as well. You did receive 1 misconduct. So it is concerning that this behavior does keep happening, and it is noted in by your parole officer that you're engaging in the same type of behaviors, since you've been on supervision. You've been on supervision since 2020. So it's concerning that there's the same behavior over and over again. You're aware there's a new protective order now as well in regards to that case.
Yes, ma'am.
Yeah.
Can I just speak on one thing that you did
Go ahead.
mention? You did mention that it does come up as a domestic. However, during the court proceedings of this particular case, the judge did bring up on record that there was a mistake, that it should have been put down as a domestic. I have never lived with the woman that is the victim in this case. I was never actually her boyfriend in the case. We were just friends. And everything was VIA. I'm calling her too much and I'm making threats. There was never any physical contact with the victim.
Right. Well, it
So-
doesn't have to be. It doesn't have to be physical contact for domestic violence. Which
So
I'm
the
sure
judge in the
you've
case
learned
actually-
in group. You know that's there.
Yeah.
What domestic violence is, and it doesn't have. You know, it's just you have the same patterns, and I'm sure you're aware of that, and that's why you're involved in the programming you're involved in. Which I do encourage you to complete when you do go back out there. But based on all this, I'm going to recommend that parole be revoked, to be re-paroled for August 5th of 2026. This is approximately a year period confinement as a sanction since your return to custody. I recommend the following parole conditions. I am putting your sponsor down, but because I have to put the condition of parole to your detainer in mass, we put halfway house on there in the event that something happens and you're released before the sponsor can be approved or any issues. That's why that's on there. So no consumption of alcoholic beverages, a general no contact with Naomi O'Connor without permission from your parole officer, behavior management program for domestic violence, no contact with your victim, CCR, C, and MLM, mental health eval treatment deemed necessary, no contact with minors, problem sexual behavior treatment, and parole to your BOP detainer in Massachusetts. My findings are going to the parole board on November 20th. So you will receive an official written decision from the board about a week after 11/20. So the board can lessen the sanction. The soonest you can be released is 12/1/25. So the board can lessen it to as soon as 12/1/25. Anytime in between the date that I recommended of 8/5/26. They can parole you later if they like to. So if they want to hold you in longer, they can. They call you back and you'd have a supplemental hearing. And then they would discuss the reasons why they may want to exceed my recommendations. So just so you know that that's a possibility as well. Do you have any questions?
I do not.
Okay. So I wish you the best, sir. And like I said, you'll know about a week after. You can also speak to the attorney's office.
If you want to call our office the day after the 20th, we'll let you know if the recommendation was accepted or not.
All right, thank you.
Okay, so you're all set for today, sir. I wish you the best of luck.
Thank you very much.
Good morning,
Good morning.
Mr. How do you say your last name?
Blatch.
Latch. So we're here today for your rev hearing. I have your attorney here, so we're gonna get started, okay? Good morning, I am P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. It's revocation hearing concerning Blatch Darrell, number 154081. Today is November 12th, 2025. This hearing is being conducted via video at the BOPP Central Office in Cheshire Correctional Institution. This is a public hearing. Public access for this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Darrell Blatch, 154081.
Thank you. You have counsel here today. Identify yourself for the record.
Good morning, Peter Matthews, the Public Defender's Office, Mr. Blatch.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I will reinstate your parole. We can release you and place you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we will review the parole violation charge the state appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all of the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
At this point, no.
Okay. Your important rights say the right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes, I did.
Okay. You have a right to review the evidence. You have a right to submit evidence for your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine other witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so we'll now review the charge the state or false is bringing against you and the information underlying each charge. I will note that at the time of the preliminary hearings, there is no findings made on charge 1 curfew and charge 3 notification of arrest. So those charges are not taken into consideration today. So charge 2 obedience to law. Your charging officer reported on 10/13/22. You read inside knowledge of special parole conditions indicating understanding that you are not permitted to use or have in possession or control any illegal drug, narcotic, or drug paraphernalia. On 8/27/25, during a home compliance check, PO found crack cocaine and crack pipe in your bedroom. Also, digital scale used for measuring drug weights was found in your vehicle. Bloomfield PD was called to the scene and you were issued a summons for the following: illegal possession of controlled substance, possession of drug paraphernalia, scheduled to appear in court on 9/3/25. On 8/27/25, during a home compliance check, PO found crack cocaine and a crack pipe in your bedroom. You were ordered to have in your possession or have control of these items. You were given oral tox and rendered positive for cocaine. Charge 4 drugs. Your charging officer reported 8/27/25 during a home compliance check. You also found crack cocaine and a crack pipe in your bedroom. You were not to have in your control any illegal drug, narcotic, or drug paraphernalia. You rendered a positive oral tox for cocaine. During transport, you requested for this PO to inform your dad that you were being returned to custody due to your drug addiction. And charge 5 travel. Your officer reported 4/5/25. You were given a citation and charged with unsafe operation of motor vehicle. You were in location of State Street and Dwight Street in Springfield, Mass. You left the state of Connecticut without prior written permission of your parole officer. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, conditions of special parole, B, remand in custody, C, parole violation report, D, also parole violation, E, Mass uniform citation, F, Bloomfield PD report 22647, and G, decision information summary. H was not received. And that was noted at the time of the prelim. Did you receive notice of parole violation report, and those other items I marked? Did you review those?
Yes.
Okay, and counsel has followed the following exhibit that is pre-marked for identification purposes as Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue to contain any additional evidence?
I do not.
Okay, we have no witnesses today. So at this time, before that, I do want to put on the record, I received the addendum from PCS. The addendum reported at 9/25/25, were convicted of possessing a controlled substance first offense and received an unconditional discharge for all the charges nolly. So now I'll turn it over to counsel.
Yes. With regard to the charges, Mr. Black did plead guilty to possession of a controlled substance, and he did receive an unconditional discharge on September 25th. From the very beginning of his remand, Mr. Black accepted responsibility for the crack cocaine and the crack pipe found in his room. He did indicate that he relapsed and he took responsibility for what happened. As I indicated in the preliminary hearing, the quantity of cocaine was very small. The police report indicated the quantity of narcotics was under 0.01 ounces. There was minute quantity of drugs that were found. I would like to be heard further with regard to sanction. Thank you.
Thank you. All right, so what I'm gonna do is I'm gonna announce my findings in regards to those charges. So in regards, as I said, charge 1, charge 3 not taken consideration. So regarding charge 2, I do find you violated that conditional obedience to the law. This is based on your conviction of possession of controlled substance first offense and received an unconditional discharge for all other charges nolly. Regarding charge 4, I do find you violate conditioned drugs based on evidence provided, exhibits A, C, and F. And regarding charge 5, travel, I do find that you violated that condition based on evidence provided, which is exhibits A, C, and E. So that includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, please, thank you. So Mr. Black, he's 55 years old. He was born and raised in Connecticut. His family still resides in Connecticut, including his father and 3 sisters who reside in the Bloomfield area. Prior to his remand, Mr. Black was sponsored by his father, and he would like to return to this address after he is released from incarceration. His father is currently 99 years old, and he has depended a lot on Mr. Black to assist him with his care and his day-to-day activities given his age. Mr. Black was employed at HPC Food Services in a warehouse. He'd been working there full-time for the past 2 years. He is hopeful to be able to return to his position when he's released, but he's also worked in various positions at grocery stores and restaurants in the past. He's always been able to maintain consistent employment over his parole supervision and is confident he will be able to obtain employment when he's released in fairly short order. Mr. Black is also interested in completing a business management degree program that he is almost complete at this point. I think he has like two credits left or something for his degree. So over the course of parole supervision, Mr. Black has cooperated with parole directives. He did initially undergo an evaluation at CRT back in 2022, and no treatment was recommended. He did consistently make his appointments and consented to all the drug tests which were requested. Based upon the cocaine use, which was the basis for this remand, we understand that additional counseling and treatment would be beneficial, and he is certainly willing to undergo any additional treatment that parole feels would be warranted at this point in time. He was released on parole supervision in October of 2022. He transitioned to special parole supervision in March of 2023. So he has been under supervision for this particular offense for close to 3 years prior to his remand. This is his first violation of parole. There were no additional misconducts in the PBR other than those which were listed in the charges which make up the basis for this violation. So it appears that Mr. Black was under supervision for several years, and generally he was doing fairly well with his parole supervision for the majority of this period of time. He has demonstrated the ability to work with parole and cooperate with his supervision. There was a drug relapse here that resulted in the cocaine residue and crack pipe located in his room. As I indicated, he was forthcoming with regard to this issue, and the quantity of drugs recovered is very small. There were no scales or cash recovered from the residence, which would suggest anything more than a relapse and personal use. Mr. Black has been remanded for about 2.5 months now. It does appear that criminal possession charge was resolved fairly rapidly in court and favorably to Mr. Black, which also provides some evidence that the prosecutors, after evaluating the case, did not feel any additional incarceration or supervision was warranted based upon the facts of that case. I would ask you to consider releasing Mr. Black at the next available date to allow him to continue with his parole supervision. Mr. Black, is there anything you'd like to add at this point in time?
I thought my parole officer was going to be here.
No.
Because there was a few questions I had for her that I wanted to put on record, but now she's not here.
You know,
I mean, so now I'm like, I had something that I want to say, and she.
Well, if you want to make a statement, Mr. Black, you can make a statement if you want to say something.
And this is recorded, and this will be for public viewing.
you're
right?
live streaming you're live streaming.
Okay, yes, I have I want to put this on record.
Oh, I'm gonna swear you under oath. So can you please raise your right hand? If you would like to speak, I have to put you under oath. You solemnly
Yes.
swear, solemnly affirm, as the case may be, the evidence shall give concerning this case should be the truth, the whole truth, and nothing but the truth to help you God upon penalty of perjury.
Yes.
Okay.
Yes, I would like to state that on August 27th, I complied to my home compliance check. 3 years on parole, and I've never had home compliance checks come back to back the way they did. She entered my home and told me that she was there for a compliance check while placing me in handcuffs, which was never done before. She then proceeds to have my whole entire home searched, also, which was never done before. Top to bottom, closets, basements, she's never done that before. It's always come into my house, my room, you working, leave. Then I find out there were items took from my home. Where is the reasoning for taking items out of my home? Items were took from my home.
Well, sir, are these things you want to address with your officer at like another time, or is this in relations to? Because we already have. I mean, you pled guilty to the court.
Well, yes, I'm
just wondering how this is. I understand that you have some issues, obviously, that sounds like you want to address with PCS. Is it related to what we're doing moving forward?
It basically all does basically down to this. Yes, if I could finish, you will see my.
I'm just making sure that's related to what, because I understand that people have issues with or have questions regarding things, but that I cannot answer. So
right.
That's why I'm just making sure that it's pertaining to what we're doing right now.
Right. This whole thing is pertaining to police contact, which was initiated by her. It was initiated for the summons that was given to me for the drug paraphernalia, for the controlled substance. The officers clearly state that I'm not under arrest. This is just a summons for you to appear in court. She takes that she initiated to remand me to custody. She remands me to custody for that and then commits to continuously searching my home. And items were took from my home. For what reason? That's why I wish she was here. I wanted to know why.
Right. That's why I said you need to address these issues with PCS. Not we have nothing to do with that.
The whole violation stems from the police contact that she initiated. You know, it was a fishing expedition that led to an investigation. And now here I am facing this, and these charges, they've already been dismissed. So now I've been sitting in here for 2.5 months and over some minute drugs that, yes, I pled guilty to. So she violated my rights. Plainly, clearly, I've been violated. Plainly. She willingly and maliciously did what she did with other departments, other jurisdictions. I wanted this on record. I wish she was here so I could ask her. I know you said she's not, but all that stems to this violation. because she initiated the police contact by calling, not I. There was really no reason for her to come to my home, when she just came to my home less than 60 days, 70 days ago.
Well, parole can come to your house many times as they would like, if they have, they can go,
understand.
they can go. I mean, you know how it is. You know that they can't
understand
do
that.
that.
Yes, I do. I understand that. However,
Okay.
being on parole for 3 years, that's never happened.
Well, it doesn't mean it can't happen, just because there's no history of it, you know? So I understand what you're saying, and it sounds like you have issues that, are related to PCS. And so we're gonna move forward now with, we've already been through the findings of everything that I've noted. I've listened to all the testimony today. I've reviewed all the evidence provided by the state. So I'm gonna make a recommendation. So based on all I have, I am gonna recommend, well, we put a couple things on the record before that. You did receive the unconditional discharge in which you accepted full responsibility for that possession of the controlled substance. You don't have prior violations. You don't have prior misconducts that are noted. You were out in the community for more than 2 years and 5 months. That was just on special parole. You were out on discretionary parole prior since October of 22. So you were in the community for a while. Based on all of this, I am going to recommend parole be revoked. You be re-paroled for November 20th of 2025. This is approximately, just a little less than 3 months, or about 3 months sanction. I recommend the following parole conditions, which is no contact with your victim, which is Cumberland Farms, 14 West Road, West Hartford, Connecticut. This is my next available board review date that I have. So I'm presenting this to the parole board on 11/20. So if they agree with me, you'll be released that day. If they do not agree with me and they want you in longer for whatever reasons that may be, you would come back and you talk to the parole board for a supplemental hearing. That's only in the event that they disagree with my recommended day of 11/20, which is the soonest date that I have available. So do you have any questions?
At this time, no, ma'am.
Okay, so you are all set for today then. I wish you the best of luck, sir.
Thank you.
All right, thank you.